Greetings. I am Supreme L. We are here to go over some information that I know it is definitely pertinent to all of us, um, being Moorish Americans. I inquired um, a zip drive and from Dr. G and Grand National Grand Sheikh Taj Tariq Bey from the House of Ram, Reawakening Minds. And I am here to tell you it is definitely worth the notes. It has a treasure trove, definitely a treasure trove of information on here. Um, and I have pre-selected some of them, and I haven't even went through the whole zip drive. Um, but definitely have some good, great information actually. And I want to bring them up. Let's see, where did it go? The first one I want. This one actually, information came from Brother Mizraim Mantis 29. Peace and blessings to that brother. And I want to read Institutes of American Law, right? And the preliminary book. And I'm afraid that y'all can see my screen. Um, let's see. 1 second. Okay, I'm back. I had to get the phone so I can actually see. Uh, but yes, pardon me. Institutes of American Law, preliminary book of laws and government. And I want to get into the first one here. And I did a reading last night, but I couldn't get it off my phone to put it on to an actual my channel, and I just didn't understand why I couldn't put it on my channel. But we're gonna do this here, and let me see. All right, there we go. That's better. All right, so we're going to one. Laws in general. Man is a social being. Pardon me. Man is a social being, fond of the company of his fellows and always disposed to live with others. You know how we don't like to live with people, right? It is thus that families, tribes, and nations are formed. Men render to and receive mutual benefits and assistance from each other. But in such societies, there must constantly arise causes of difference among the several members, and these must be adjusted or settled, either by parties themselves or by some power which is superior to them. Their rights must also be regulated, so that the parties may know to what each one is entitled. This is done by an actual or presumed agreement of all the members of the society, state, or nation by the establishment of certain rules, which acquire the name of laws. The knowledge of these laws, or the science by which they are understood, is called jurisprudence. The first step to understand this science is, therefore, to know exactly the nature of the laws and to from to form of them a different and precise idea. By science is understood a connection of truth founded on evident principles or on demonstrations, a collection of truth of the same kind arranged in a methodical order for the purpose of making them more easily understood. 3. In its most extensive sense, the word law signifies a rule of action. And let me say that again. In its most extensive sense, the word law signifies a rule of action, which is a verb. It is a rule which all beings, whether animate or inanimate, reasonable or not, must observe. Thus we say the laws of motion, of gravitation, of mechanics, as we say natural laws, political or criminal laws. In this sense, all beings have their laws. The material world, animals, and man each have their laws. The knowledge of all these laws belongs to philosophy, which in its immensity embraces all the knowledge which man can acquire by the use of his reason. More circumscribed in its object, jurisprudence regulates only human action. Law, in this view, then, is the rule of human actions, that is, of those actions which are the result of the free exercise of intelligence and will. Law is called a rule of action by a metaphor borrowed from mechanics. A rule in its proper sense from one point to another, the shortest line possible, which is called a straight line. The rule is used in comparison in the arts in order to judge whether a line is straight, as it is used in law to judge whether an action is just or unjust. An action is just or right when it conforms to the rule, which is the law. It is unjust when it differs from it. It is not right, and so it is of our will or intention. Justice has been variously defined. It is the constant and perpetual disposition to render to every man his due, or perhaps more correctly, it is a conformity of our actions and wills to the law. Justice is interior or exterior. And I was talking to my brother, Ms. Rain, earlier about just this statement here. Uh, Justice is interior or exterior, and he had a valid point. He was saying earlier that we are always looking outside, exterior for, justice, and we really got to recognize that it comes from within us first. It comes from within outward. Um, We got to look inside ourselves first to recognize the justice we have within, to formulate that, to show it on the outside or exterior. That was really a great conversation. The first is, and I digress, and we continue. The first is the conformity of our will, and the last of our actions to the law. The union of both makes perfectness. The last is alone the subject of human jurisprudence. Interior justice is the object of morality. In the most extensive sense of the word, justice differs but little from virtue, for it includes within itself the whole circle of virtues. Yet, the common distinction between them is this: that which positively and in itself is called virtue when considered relatively with respect to others has the name of justice. But justice being in itself a part of virtue is confined to things simply good or evil, and consists in a man taking such a proportion of them as he ought. 8. To make a law, there must be a superior who has authority to make it, and an inferior who is bound by it. To complete the definition of law, we must say that it is a rule prescribed by a lawful superior. God is the first great superior. Peace and order in society would not be guaranteed by the principles of human legislation if those principles were not protected by the salutary influence of true religion. And human laws would be insufficient to regulate the conduct of man if their action was not supported directly and supplied by religion. And morality and religion would be of themselves be powerless to ensure the peace of society without the aid of the civil law. Many moral obligations exist which are not enforced by the civil law, and these are left to the operations of the conscience, such for example as gratitude and benevolence. 9. The law of nature, or natural law, is that which God, the sovereign of the universe, has prescribed to all men, not by any formal promulgation, but by the dictate of right reason alone. I want to read that again so we can hammer that home and make sure we get a full grasp of that, because what we are seeing in our society now is definitely not natural law, and natural law is not being prescribed. Almost it's nil. But 9, the law of nature or natural law is that which God, the sovereign of the universe, has prescribed to all men, not by any formal promulgation, but by the dictate of right reason alone. It is ascertained by a just consideration of the agreeableness or disagreeableness of human actions to the nature of man. And there are footnotes here, and I know we didn't see. Yeah, we had some back up here. So if you get that, once you get this zip drive and you get this information, and again, you can have the footnotes, and we must not forget the footnotes there. So, and again, it is ascertained by a just consideration of the agreeableness and or disagreeableness of human actions to the nature of man, and it comprehends all the duties we owe either to the Supreme Being, to ourselves, or to our neighbors, as reverence to God, self-defense, temperance, honor to our parents, benevolence to all, a strict adherence to our engagements, gratitude, and the like. By natural law is also understood the system or collection of those laws arranged together in a methodical order The law of nature is superior in obligation to any other. Let me read that again. And we need to make sure we get that, like, yay. The law of nature is superior in obligation to any other. So, not, notwithstanding anything else, the law of nature is superior. It is binding in all countries and at all times. No human laws are valid if opposed to this, and all which are binding derive their authority either directly or indirectly from it. That's deep. It's not so deep, but it's deep. And a lot has been forgotten about that. And we need to use this. This is what should be in the front of our lobe and on the tip of our tongue. 10. The law of nations is a system of rules deducible by human reason from the immutable principles of natural justice and established by universal consent among the civilized nations of the earth in order to decide all disputes and to ensure the observance of good faith and justice in that intercourse which must frequently occur between them, or it depends upon mutual compacts, treaties, leagues, and agreements between separate, free, and independent communities. The law of nations, jus gentium, I hope I didn't butcher that, but jus gentium, GM, has of late years been called international law. Nations, with regard to each other, are considered as individuals, and the law of nations is to regulate the differences which may exist between them and their national capacity. They are in a state of nature and must be considered as so. Many free and independent persons living in that state, and therefore the rules of natural law are to be applied to them. International law is generally divided into two branches: the natural law of nations, consisting of rules of justice applicable to the conduct of states; the positive law of nations, which consists of the voluntary law of nations derived from the presumed consent of nations, arising out of their general usage; the conventional law of nations derived from the express consent of nations as individuals, as evidenced in treaties and other international contracts or compacts; the customary law of nations, which is a tacit consent to certain rules which have been observed by them. The law of nations has been divided by writers into necessary or voluntary, or into absolute or arbitrary, by others into primary and secondary. Prime first, of course secondary is second, which latter has been subdivided into customary and conventional. Another division is made into natural and positive. The various sources and evidence of the law of nations are the following: the rules of conduct deducible by reason from the nature pardon me, excuse me, of society existing among independent states, which ought to be observed among nations; the adjudications of international tribunals, such as prize courts and boards of arbitration; text writers of authority; ordinances or laws of particular states prescribing rules of conduct of their commissioned cruisers and prize tribunals; the history of the wars, negotiations, treaties of peace, and other matters relating to the intercourse of nations. excuse me. We need to go back and look at that because it says the history of the wars, negotiations, treaties of peace. And that should ring a bell to most of our people because we do have a treaty of peace and friendship there, which we may be briefly getting into. Treaties of peace, alliance, and commerce declaring, modifying, or defining the pre-existing international law. So let's see that right now. Let's go to which I know I had it up here, but we do have it. We do have it. We do have it. Um, I thought I had brought it up, but I didn't. Pardon me. I apologize about that. Um, I thought I had put it up on the board, but I see that I didn't put it on the board. But ah, it's on here. I know it's on the zip drive. I know it's on the zip drive, but we'll just go here. Um, there it goes. We can just do it this way, and it should come up. Uh, yes, we do go to our university. Uh, we do go to our university here. Yeah, we should go here, and it should take us right here to it. No, what was that? That wasn't it. Okay, this should be it right here. Okay, this of course is what we have. This is our Treaty of Peace and Friendship, 1787, between Morocco and the United States. And I would implore you to go to RV Bay Publications and check that out. All right, and then we can get into here. I wanted to get into nationality. All right, we're gonna get into nationality and knowing that we are. They look at us as chattel um, or not real. Um, here, this is for who consider themselves black, Negro, or colored. You were held under these auspices as they had codes for you. That's why we could never be Negro, black, or colored. Because if you do consider yourself to be black, Negro, or colored, these codes still apply to you today. So be careful who you say uh, that you black. Okay, okay, all right. Christian Black Codes of 1724, March 1724, Article 1. They have all these articles. All these articles. Children, Article 9. Children issued from the marriage of slaves shall follow the condition of their parents, and shall belong to the master of the wife, and not of the husband, if the husband and the wife have different masters. Mm. Master 11. Master shall have their Christian slaves buried in consecrated ground. So you had to be a Christian. They forced you to be a Christian. And I'm not saying negatively about Christians, but we have a nationality, so we all come from a background. So, but 15, we forbid Negroes to sell any commodities, provisions, or produce of any kind without the written permission of their masters, or without wearing their known marks or badges. And any person purchasing anything from Negroes in violation of this article shall be sentenced to pay a fine of 1,500 livres, which is a pound. If you look up the livres, means a pound. So coming from the French. Um, and then it says you have, if they're wearing marks or badges. Wow. Wow. And 13, 13 is something when I read the other day. 13 was it jumped out to me. It's like um, 13. We forbid slaves belonging to different masters to gather in crowds either by day or by night, under the pretext of a wedding, or for any other cause, either at the dwelling or on the grounds of one of their masters, or elsewhere, and much less on the highways or in secluded places, under the penalty of corporal punishment, which shall not be less than a whip. In case of frequent offenses of the kind, the offender shall be branded with the mark of the flower delusion, and should be and should there be aggravating circumstances, capital punishment may be applied. So, but anyway, I was saying the flower de luce. Uh, let's look that up. Let's look up that. And a lot of people may know what that is. A lot of people don't know what that is. But remember, they branded people with this flower. If you were a slave and you were found to be, to become a Latino, okay. Yeah, flower delusion. Let's see here. Look at this flower, right? Um, uh, let's see. Flower delusion. Then we're gonna go. Let me see here. This is crazy. This is crazy. The black code was a regulation adopted in Louisiana in 1724 from other French colonies around the world. Remember, that was a Frank. But the flower is, this is the flower. This right here is the flower. And if everybody knows, this is what's on the New Orleans Saints helmet. And they're the New Orleans Saints. Oh, and it goes right here. Saints fans weighs in on the flower associated with it. That is crazy. But yes, this flower was. If you were a slave back then, y'all foremothers and forefathers, quote unquote, acted out of place, and they got out of place. They were branded with this quote unquote flower. And again, uh, this is dominant in New Orleans, Louisiana. So that's something to think about. It caught me, it caught me by surprise. I had to look that up, and I did look that up. I'm glad I did look that up. But uh, moving on, and because there's a bunch of them, it's a whole bunch of articles for this black codes. So you could never, again, we can never be black. All right. So um, let's look up bankruptcy. And I had it pulled up the other day. Let me see if I still have it. Uh, I know I saw it the other day, but it's gonna go into the bankruptcy of the United States company, and it is evidence of the company that United States is a company and not the land. The United States company is a company, not the land. The land is Morocco. Societas Republica et al. Moroccanas. But I need to, I just gotta remember where I saw it. Um, I'll pull it up. I thought I had it, but I didn't pull it up there. But anyway, 1925, you can see and look it up that the United States Corporation was incorporated in Florida. Their last register was in Florida in 1925, and their address was in New York. Their postal address was in New York. All right, but we know, and we're gonna look and go into the bankruptcy. All right. In the matters of the House Joint Resolution 192, 73rd Congress, the U.S. bankruptcy. Martial law has been in effect since then. So a lot of people think martial law is coming. Martial law has already been here. So, and we skim down to okay. Let's start right here. Study the nature of the frauds and of the attending unconstitutional issues that brought about the conspired U.S. bankruptcy with these following facts in mind. The repugnant political circumstances were not unplanned. Review the following documented information in contemplation of and in association with the preceding acts of sedition committed by an apparent dominant number of the members of all branches of a compromised governing body politic. The record shows that among the numerous acts of misprision includes the unacknowledged coup d'etat against Abraham Lincoln, who was actually the last sitting president, which took place on March 27, 1861, and leading up to the Act of Congress, February 2nd, 1871. These acts were veiled under the public claims made that expressed that the U.S. Congress adjourned sine die. And that means sine die, of course, means without a day. They haven't come back. There's no lawful Congress. Congress is not lawful since they've been adjourned since this day. The record will show that many aspects of the subverting barratry operations born among the British Accredited Registry, bar. All right, now the bar, right? Those are like judges, lawyers. You have to have a, your bar, right? And what does it mean? British Accredited Registry. British bar members was and is apparent to any diligent or credible researcher. Conspiring bar members dedicated missions of enforcing the secret Treaty of Verona and undeniable and their plans to undermine the Republic, and were, pardon me, no doubt already set in place and established. In the latter years of their barratry operations came the later follow-up via the Inquisition hegemony criminality of the U.S. President Woodrow Wilson, his anti-constitutional administration, and their feudal law-stacked Congress. Their treasonous and colorable actions and Congress fuel legislation acts were marked by the infamous meetings which took place on Jekyll Island. And we do have, I want to show you real quick and we'll jump back to that. It is a book right here. There's a book. If you can get it, I implore you, you ought to get it. Alright, this book here is called Creature from Jekyll Island. Alright, the book is called Creature from Jekyll Island. The Creature from Jekyll Island. A second look at the Federal Reserve, 3rd edition, by G. Edward Griffin. I implore you, you ought to get this book. And later in a week, we will be going into this book in depth. Okay, but to get back to the bankruptcy and to follow up here, conjoin these known misdeeds to the unconstitutional acts which were held as key to abrogating the organic constitution and for solidifying the political foundations that laid the groundwork for the later established private and unconstitutional Federal Reserve banking system in 1913. And with this entry in place, the bar operatives were enabled to impose their Inquisition Revenue Service, IRS. The contemporary political cover for that old entity is now the IRS, Internal Revenue Service. But remember, that is the Inquisition Revenue Service, established in 1916. These and other unconstitutional acts committed by the members of the Bar Association, past and present, continue with the institutionalized, injurious, and ongoing effects of the following. Franklin D. Roosevelt and the U.S. Congress waged war against the Republic's Constitution. And let's stop for a second because and I hear a lot of people, even, when I was younger, and I'm in my high 40s now. Democracy. Everybody's saying democracy. And then we were taught as a people of our hue that republic is not for us. Is the Europeans and stuff like that. That's their party. And actually, the Constitution only states that we have a right to a republic. There's no democracy in there at all. And actually, if you look at the word democracy, it looks like demon. So you really have to look at it like that. But I digress. The fact of the matter is the United States Corporation did go bankrupt in 1933 and was declared so by its President Roosevelt by Executive Orders 6073, write those down, 6102, 6111, and by Executive Order 6260 on March 9, 1933. This was executed under the Trading with the Enemy Act. Write that down. Trading with the Enemy Act on October 6, 1917. as amended by the Emergency Banking Relief Act 48 Stat 1 Public Law Number 1, which is presently codified in 12 USCA 95A and confirmed at 95B. You can confirm and verify this for yourself by reading the journals of the House of Representatives, or you may also find it on findlaw.com. Therefore, U.S. Congress confirmed the bankruptcy on June 5, 1933, and thereupon impaired the obligations and considerations of contracts through the joint resolution to suspend the gold standard and abrogate the gold clause, June 5, 1933. See House Joint Resolution 192, 73rd Congress, First Session. Article 1, Section 10, Clause I, 1 of the Constitution for the United States is shown as follows for your review and examination. Article 1, Section 10, Clause 1 of the Constitution for the United States. For the United States. No state shall enter into any treaty, alliance, or confederation, grant letters of marque, and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bills of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. When the courts were called upon to rule on the constitutionality of various aspects of the provisions designed to implement and complement Franklin Delano Roosevelt's Emergency Banking Relief Act of March 9, 1933, they were all found unconstitutional. In order to assure the bar's planned obligation against the Constitution, Franklin Delano Roosevelt used the presidential office to stack the courts with his and the bar's chosen obsequious members of the bench and bar. He then sent many of the cases back through the Reconstruction Court and reversed the former court rulings which declared these actions as unconstitutional. Fraud, treason, fraud, treason, fraud, treason, fraud, treason. Acting repugnant to the Constitution, House Joint Resolution 192, Stat 48, Stat 112, was passed by Congress on June 5, 1933. The act impaired the obligations and considerations of contacts and declared the private for-profit commercial debt notes of the Federal Reserve banks were legal tender for the payment of both public and private debt, and that payment in gold coins was against public policy. So wait, now what they're saying right now, if I'm like a thinking man, like we all should, again, they just went against the Constitution. They said to hell with the Constitution. They said to hell with the Constitution. We ain't worried about that. You're gonna use these notes we got. That's gonna be your money. Wow. For the payment of both public and private debts, and that payment in gold coins was against public policy. Not law, but against public policy. In effect, Franklin Delano Roosevelt and the compromised U.S. Congress, acting under executive orders and legislative fiat, criminally abrogated Article 1, Section 10 of the Constitution and nationalized the people's money, i.e. under a color of authority and under a color of law, stole the people's gold coin. Nationalization is a violation of the law of nations and existing public policy of the U.S. Congress. See Hilton versus Guyot, 159 U.S. 113, 1895. The people's gold coin that was unconstitutionally confiscated corporately and nationalized was later used by Roosevelt congressmen and the bar members to purchase voting stockholder shares in the bank and the fund at 35 per ounce. At this point in time, fair market value, i.e., a willing seller and buyer without compulsion, lost any substantial meaning. Wow, that is crazy. That is crazy. And then it has the several state governors agreeing to misprision. Then we go on and then it says the compromise Supreme Court, Bar Association members. And again, what does bar mean? What does bar stands for? British Accredited Registry. Wow. It's fraud all everywhere. And we got to get it back right, y'all. That's what the Prophet Noble Charlie was saying. We come and be in, in unity and we get back in the right state. We have to get this together. It's going to be up to us to get it together. We're gonna let the chips fall where they may, but we're gonna be the ones that's gonna have to pick them up and put them back in the package right. The United States private for-profit foreign corporation. This is the fundamental change necessary to effect unification of civil and admiralty procedure. Just as the 1938 rules abolished the distinction between actions at law and suits in equity, this change would abolish the distinction between civil actions and suits in admiralty. Mm. The administrators of the United States therefore entered the Second World War, during which time the League of Nations, y'all write that down and look that up, League of Nations was instituted under pretense of the United Nations, 22 USCA 287, and the Bank for International Settlements were instituted under the color and under pretense of the Bretton Woods Agreement, set at 22 USCA 286, as the International Monetary Fund, the IMF, and the International Bank for Reconstruction and Development, the bank or World Bank. The United States is a for-profit corporate body politic artificial. I'm going to read that again. The United States as a private for-profit corporate body politic artificial came out of the World War II in worse economic condition than when it entered, and the conspirators operating under a color of authority in 1950 declared bankruptcy and reorganization. The reorganization is located in Title V of the United States Codes Annotated. The explanation at the beginning of 5 USCA is most informative reading. The Secretary of Treasury was appointed as a receiver in bankruptcy. Let that sit for a second with you. And this is for all my people that's going through a bankruptcy or plan on going through a bankruptcy. Or they're telling you that it's good to go through a bankruptcy. How could you go through a bankruptcy if the U.S. company is already bankrupt? We should be discharging because you could never pay for anything. There's a difference between paying and discharging. There's a difference between wages that you go to work for and spend energy for and the difference between income. You have your income. Income means that you are corporate. That's corporatizing. That means you're a corporation if you say you receive income. Corporate and corporations receive income. Natural beings work and get wages, pecuniary wages, which can't be forced to be given out for anything. They can't demand you to do anything with your wages. You do as you please. If you say you have income, they can demand you to spend income and pay, quote unquote, that income because you are a corporate or a corporation if you say you have income. No constitutional authority to act. It is important to take cognizance of the fact that no constitutional amendment was ever obtained to fundamentally change, amend, abridge, or abolish the constitutional mandates, provisions, or prohibitions, but due to international and external diversions surrounding the Vietnam War, etc., the usurpation and breach went unchallenged and unnoticed by the general public at large, who had become a wealthy man's cannon fodder or cheap source of slave labor. See, they go off of our energy. They go off of our energy, right? They go off of our energy. That means you can't you're supposed to be discharging all quote unquote debts. All quote unquote debts. Here, creditor and their bonds. Alright. Bond for discharge. This is the creditor holder side of the bond, evidence of a debt. When you use a bond for discharge, you are using your credit backed by the implied bond debt resulting from your pledges to help the United States through its bankruptcy. Bada bing. There is no value limit to this bond, as you voluntarily agree to pledge every bit of substance you ever get until the money is put back into circulation, i.e., gold and silver coinage. All the substance you have, cars, dirt, shoes, food, toothbrushes, was acquired by giving the merchants Federal Reserve notes. You can never get title to things unless you pay for them. Since there is no money in the U.S., only debt paper, every time you get a pair of shoes, you are exchanging a debt for the shoes. In the U.S., since 1933, that is an acceptable practice. Outside of the U.S. and its states, in the states, that is not acceptable. See, the waters is choppy that we have to navigate, but we can navigate them. We just have to find the information that'll help us. Now, I'm not one for the number on your bond or authenticate this and authenticate that and turn it over and put your grandmother's grandfather's birth date and their number on the back of it so you can say I'm not into all that, though that is a form that you can use. I just know by claiming your nationality and being who you are, in full life being, and putting it on the record, because what the prophets say, if you don't do anything else, proclaim your nationality. Now I do know some people that do, do the accepted for value and use the credit, the unlimited credit or whatever, the bottomless finance or credit that they have according to the House Joint Resolution 192, and I'm not opposed to that. But I do know the first thing you need to do is claim your nationality. You can't do nothing else without it. All right, and we're gonna bring it to a pause right there. And when we do come back, it's gonna be other books like this book here that we want to get into. This is one of the books that's on here that's really good. It's called Paper Arrows. Thine arrows are sharp in the heart of the king's armies. Alright, this is a good book here. This is a good book too. And then we're gonna get into, we're gonna finish up with the creditors and the bond. We're gonna finish up with the one of these right here. This is a good one too. This exposes a lot of the fraud that's going on with cars and houses and the property of the foreclosure defense handbook. This is really good by Vince Kahn. This is really good book. I read a lot of it so far, and it's really good. So we're gonna get into that too. Um, Also, a book that National Grand Sheik Tariq Bey. We'll get into his book here. Let me go up, push it up here, and we'll see. There you go. Okay. No. Well, anyway, it's a CMB certificate number, and we're going to get into that. Why did it just go blank like that? But anyway, yeah, and that's what we're going to get into. We'll get into others too, especially the civil order from July 4th, 2014. Um, Issued to all members of domestic police forces, U.S. Marshal Service, the Provost Marshal, members of the American Bar Association, and the American Armed Forces. All right, we're going to get into that too as well. And again, we're going to get into this too. This is a good one. On the next one, when we come back and return, we're going to get into this. Banks can't own property. And these are case laws that you can use. Okay? You can use. So if they say that you owe them because you are on their property, banks can't own property. Okay? They can't own it. They can't own your car. They can't own your house. They can't own your land. They can't. So that is something that we'll be getting into. And these are case laws. So again, I do employ you to reach out to House of Ram, Reawakening Minds, and inquire about the zip drive, because it is a treasure. It's definitely a boundless treasure. So again, I want to thank you for your time, and we will be coming back on here and following up. I'd like to thank Prophet Noble Drew Ali, Sheikh Sharif Abdul Ali. Getting back around to it. I wasn't neglecting the family, but I had to take some time. But I will be moving forward and continuing and to do my part in the upliftment of fallen humanity. And again, I love all of y'all, which is one of our principles. The first principle: love, truth, peace, freedom, and justice to all. All love beats all. With that being said,